Did you know government officers once faced a refund for hiring private lawyers? What's the fair line between public duty and private legal advice? This is the case entitled Pelagio T. Recalde, et al. Versus Commission on Audit, GR number. 253724, date of promulgation. February 15, 2022.
This is the 42nd case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Follow for more.
Facts of the case. The Bureau of Investments, BOI, engaged lawyers Atti. Dennis R. Gascon, Atti. Francesca R. Custodio Manzano, and Atti. Madonna N. Clarino under service agreements. Atti. Gascon and Atti. Manzano were assigned to the offices of BOI Governors Oliver B. Butalid and Pelagio T. Recalde respectively, while Atti. Clarino was assigned to the office of BOI Executive Director Efren V. Leaño. Their roles involved reviewing documents, preparing draft schemes for investment incentives, rendering legal opinions on complex issues, attending hearings, representing BOI in various capacities, and providing legal support and advice. In 2012, post-audit notice of disallowances were issued against the salaries paid to these lawyers, totaling P797,790.77, on grounds of non-compliance with COA Circular No. 86-255, which required the conformity and acquiescence of the Office of the Solicitor General, OSG, and the written concurrence of the COA for such engagements. The BOI appealed the disallowances, arguing the inapplicability of the circular as the lawyers were hired as technical assistants and not for legal representation, and asserting Atti. Clarino's non-practitioner status prior to her engagement. The COA National Government Sector, NGS, Cluster 8 upheld the disallowances, stating that the service agreements required performance of legal services, thus falling under the ambit of COA Circular No. 86,255. The decision was later modified to exclude the lawyers from liability. The case was then brought before the COA proper, which affirmed the disallowance with modification, releasing the lawyers from liability but maintaining the liability of the BOI officers. The petitioners sought judicial review, contending the inapplicability of the circular and asserting the BOI's need for technical assistance. They also sought an equitable resolution for Fondavilla, who failed to seasonably appeal the COA NGS Cluster 8 decision.
Primary issue. The primary issue revisited is whether the COA proper was correct in sustaining the disallowance of the payments made to the lawyers and in holding the BOI officers liable.
Decision of the Supreme Court. The Supreme Court partly granted the petition. It affirmed the decision of the COA proper but modified it to relieve the approving and certifying officers of the obligation to refund the disallowed amount. The court acknowledged the long-standing rule restricting government agencies from hiring private lawyers, emphasizing the necessity of securing the OSG's written conformity and COA's written concurrence. However, it recognized that the payment to the lawyers, though irregular, was made for actual services rendered, and requiring the officers to refund the amount would unjustly enrich the government.
Important doctrines. 1. Regulation of hiring private lawyers by government agencies. This doctrine emphasizes that government agencies must secure the OSG's written conformity and COA's written concurrence before hiring private lawyers. It aims to prevent unnecessary expenditures of public funds. 2. Concept of net disallowed amount. Introduced in Madera v. Commission on Audit, this doctrine clarifies the nature and extent of liability of officers in disallowed transactions. It holds that any amounts allowed to be retained by payees reduce the solidary liability of officers found to have acted in bad faith, malice, or gross negligence. 3. Principle of quantum meruit in government contracts. This principle allows the reduction of civil liability for disallowed amounts based on the services actually rendered, preventing the unjust enrichment of the government at the expense of public officers or contractors.